Hey, how you doing? It's Alex William Smith here by birth, but better known by my stage name, Jonathan Royal, hypnotist of magicalguru.com and circusofthemind.net. It's the 6th of June 2022. Just wanted to update you that I've got confirmation today, as you'll see on screen in a minute, from the Criminal Cases Review Commission that they've now got my case and have assigned it a reference number. I wanted to draw your attention to some interesting things from over the years that illustrate monumental, and I mean monumental, disclosure failures by the police and Crown Prosecution Service, not just to myself, but to Mazher Mahmood fake shape victims in general. Check out this video and then go to circusofthemind.net. Hi, it's the 6th of June 2022. And I just received this, which is dated 31st of May 2022, but it just arrived today in the post, which is British Mail, on the 6th of June 2022, which you can clearly is from the Criminal Cases Review Commission, confirming that they have received my application that was submitted to them last month, and that it now has a reference number of 00446/2022. So it'll be interesting to see what happens with this. All the details are on circusofthemind.net. But I wanted to draw your attention to some interesting comments that people have made over the years in relation to this, and that point towards there being a cover-up of, as some others have suggested, police and cover up with the Crown Prosecution Service, and also mention of potential police corruption. Comments that can be seen at circusofthemind.net, but also you can see them on screen and I'll read them out to you. It is as we have long suspected that the Met knew and repressed information about corrupt relationships between their officers, employees of the News of the World and Southern Investigations. This information was deliberately repressed by the Metropolitan Police and should have been disclosed to those representing defendants in the so-called stings orchestrated by Mazher Mahmood. It is information which should be immediately disclosed to those lawyers advising relevant convicted individuals whose cases are now before the CCRC and the Daniel Morgan investigation panel. That was Siobhan Egan of Lewis Nader's Law, quoted from circa 2014 and 2015, and yet there has still been no disclosure other than a disclosure pack regarding the collapsed trial of Talisa Kontos-Stavlos, which the CPS issued towards the end of 2014 to myself and other Mahmood victims. But nowhere in that did it mention, and nowhere prior to that did they ever disclose. And since then, they have had many opportunities but have not disclosed any of the information they had of collapsed trials, where trials collapsed because of Mazher Mahmood's dishonesty coming to light and because of the police and CPS deciding that they couldn't rely on him as a witness of truth, of which there is evidence going back to 1994. Yes, 1994, of a collapsed trial and documents showing communications between the police and the CPS saying that they could not rely on Mahmood. And yet none of that was disclosed to me in 1998 or to any of the other Mahmood victims over the years. And to this day of doing this, the 6th of June 2022, the CPS have never disclosed anything to me regarding what they know, other than a little bit regarding Talisa Kontos-Stavlos' collapsed trial in 2014, which is interesting given that there's definite proof that they knew in 1994, a good 4 years before Mahmood ever entrapped me in his sting, that he could not be relied upon as a witness of truth. People who have been locked up in the past are now able to say there is compelling evidence that this man was prepared to lie on oath in order to secure a wrongful conviction. So there's now a platform for others to come forward and say the same thing happened to us. Jeremy Dine QC, who was Talisa Kontos-Stavlos' barrister. And in that case, incidentally, it was alleged in court that Mahmood and his team had spiked or drugged Talisa and her friend's drinks. This is something that now seems even more likely, and I've always thought may have happened to me and other victims. Loads of victims over the years have claimed this, but I now have a statement from Steve Grayson, who was a former work colleague of Mazher Mahmood, stating under penalty of perjury to support my appeal case that he witnessed Mahmood tamper with and add drugs to sting victims' drinks, and that this is likely to have happened in other cases, including mine. Okay, we continue. There were strong grounds for believing that the underlying purpose of these lies was to conceal the fact that he, Mazher Mahmood, had been manipulating the evidence in this case by getting another witness to change his account. Judge Alistair McCreath told the jury. Next, Mahmood has now been exposed by my lawyers openly lying to the judge and jury. These lies were told to stop crucial evidence going before the jury, she added. Thankfully, the lies have been uncovered and justice has been done. That was Talisa Kontos-Stavlos in 2014 when her trial collapsed and Mahmood was exposed as a liar, which later led to him being convicted and sent to prison for conspiracy to pervert the course of justice. Unfortunately, despite numerous occasions prior to then and since, the Crown Prosecution Service has never disclosed anything except a little bit of information relating to the Talisa Kontos-Stavlos trial. And yet there is evidence that they knew back in 1994, when a case collapsed, due to Mahmood's dishonesty, that he could not be considered a witness of truth. Further, in circa 98-99, when investigating Southern investigations, the police became aware of stuff that also should have been disclosed to people regarding Mahmood's links to Southern investigations, and there have been a whole bunch of cases that have collapsed over the years due to Mahmood's dishonesty, that, the CPS have never disclosed stuff, which, had it been known at the time, if they were to have disclosed it, had I known at the time, my case likely would never have made court, and the same applies to a lot of other fake Sheikh victims. Judge Stuart Fish formally acquitted Mr. Giggs, that's Roderick Giggs, then asked whether charges of inciting to supply drugs and illegal possession had been considered against the reporter Mazher Mahmood. Again, a judge here casting doubt on Mahmood's techniques and whether he should face charges or not. Mr. Queen Hawkins, prosecuting, said, the position is that the Crown can no longer rely on Mr. Mahmood as a witness of truth in this case, and for that reason I offer no evidence against Mr. Gordon on behalf of the Crown. These things were never disclosed to us at the time or since, up to this date of the 6th of June 2022. None of the stuff relating to these obvious dishonest occurrences by Mahmood have ever been disclosed to us by the police or the Crown Prosecution Service. Curiously, he's, Mazher Mahmood, never been charged with the illegal purchase of cocaine, although there are no legal grounds on which he can do this to perpetrate a sting. Peter Burden, author of Fake Sheikhs and Royal Trappings. Why was he never charged for breaking the law? Why was a blind eye turned by the Crown Prosecution Service and the police? Is it because, as Mahmood once famously said, he had corrupt police officers in his pocket? I am responsible for innocent people going to jail. I tricked them to help Mazher Mahmood, and I'm ashamed. It's time to tell the truth. Florin Gashi, former colleague of the Fake Sheikh. You can actually see him say such in the Panorama BBC documentary that was broadcast towards the end of 2014, and you can watch that on circusofthemind.net. We've had the case of Mazher Mahmood, the Fake Sheikh, who perverted the course of justice to secure his scoops and left scores of previous convictions unsafe. Tom Watson, Labour MP. One is mindful about the fact that there is little regulation on undercover newspaper work and citizen investigators, which perhaps needs to be looked into. Nazir Afzal, former chief of Crown Prosecution Service in the Northwest. Perhaps what Nazir Afzal should have been doing was disclosing to Mahmood victims at the right times the information that the police and the CPS knew as far back as 1994 about his dishonesty and all the cases over the years that collapsed due to his dishonesty and such. The other thing you might want to look at, though, is the PCC code. Clandestine devices and subterfuge. The press must not seek to obtain or publish material acquired by using hidden cameras or clandestine listening devices or by intercepting private or mobile calls, messages or emails, etc., etc. And of course it goes on to say, unless there's a clear public interest. Alistair Campbell, MP. Well, there definitely was no public interest in my case, as explained at circusofthemind.net. There was no public interest in them doing a story on me because they knew that I knew who he was and that I was attempting to expose their dodgy, illegal and dishonest techniques. So there was no public interest from their point of view, but there was a public interest in me exposing their dishonesty and techniques and making the public aware that such was going on. And yet it was me that got punished at the time, not them, which is all very bizarre. What I was doing, arguably, it was in the public interest, but what Mahmood wasn't, as explained at circusofthemind.net. The fact that somebody who has been accused by a judge of apparently not telling the truth may be instrumental in those convictions would certainly be a reason to look at those convictions again and to examine them to see whether they are safe. Lord Peter Henry Goldsmith, former Attorney General, quoted from the BBC Panorama documentary of 2014. I will first deal with unlawful and improper conduct within News International and other newspaper organisations. The conviction of Mazher Mahmood also raises issues of an entirely different species of unlawful and improper conduct. Sir Brian Leveson, QC. Unfortunately, the Conservative government have swept under the carpet and cancelled Part 2 of the Leveson inquiry, which would have fully investigated things such as Mazher Mahmood's conduct, illegal techniques, dishonest techniques, and likely would have cast further light on his links with the Met Police and corruption, and his being linked in with the Daniel Morgan murder inquiry, all of which with evidence is shown at circusofthemind.net. Steve Grayson, who worked with Mahmood on numerous stories in the 1990s, including this one, said of the takedown, he is a drug dealer. We're drug dealers. We have paid this guy to supply the drugs to give to her. Steve Grayson, former Mazher Mahmood associate. Same applies in pretty much all the cases. The complete chain of supply roots back when the real evidence is shown to be Mahmood's associates and people that they paid, which is just, it defies belief. The CPS Special Prosecution Team, as it was then, dealt exclusively with these prosecutions and, in my view, did not seek to test the weight or the veracity of the evidence. As I say, there was a certain MO Mahmood would employ. The same assertions were made by reputable defence teams time and again to the CPS, which were ignored. You also have the Met Police. We now know there were internal investigations by the anti-corruption team at New Scotland Yard into Mahmood's relationship with serving police officers. That was Siobhan Egan, Lewis Nadis Law, and the BBC Panorama documentary. But that's been further illustrated when the Daniel Morgan murder inquiry report was published, where Mazher Mahmood is named and his links to Southern investigations. Over the last 25 years, innumerable lives have been ruined by the dishonest actions of Mazher Mahmood. People have lost their livelihoods, their homes and relationships, with some spending time in prison. When the public used to read fake Sheikh articles in British newspapers, they would know there was a criminal at the heart of the story. Until now, readers didn't realise that the criminal was in fact the fake Sheikh himself. Mark Lewis, the celebrity phone hacking lawyer, repeated that several times around Mahmood's downfall. The real scandal in this case is that Mahmood was allowed to operate as a wholly unregulated police force, investigating crimes without the safeguards which apply to the police. As a journalist, he was able to rely on unnamed sources and was not required to give full disclosure of his investigation to the defence. As Talisa's defence lawyers, we were prevented from properly testing the strength of his evidence. It was obvious from the outset that Talisa should never have had to go to court. If Mahmood's evidence had been properly stress tested instead of accepted wholesale by the CPS, we are confident it would have come to the same conclusion. Ben Rose of Hickman and Rose. I can add to that it's safe to say that if Ben Rose and the team, Hickman and Rose, had been given full disclosure by the CPS of what they knew as far back as 1994 and full details of all the cases that we now know collapsed over the years because of Mahmood's dishonesty, that the chances are that alone would have led to Lisa's case never having to go to court in the first place either, just as would have been the case of proper disclosure taking place for other Mahmood victims, that they would likely never have gone to court either. Red flags were raised about the reliability of Mazher Mahmood's stings over the decades, but the police ignored them. Dr. Evan Harris, who earlier this year in 2022, you can find on YouTube, on Hacked Off's YouTube channel, his statement he made outside court after getting settlement from Newsgroup newspapers for them having hacked his phone and used unlawful information gathering techniques, where he mentioned Mazher Mahmood and Mahmood's own attempts to fabricate a story against him, but he goes into information about the fact that from his mouth outside court, he states he's seen the evidence that scores of Mahmood's victims had their phones hacked and unlawful information gathering techniques used, and that Mahmood lied and manipulated and fabricated evidence and such like. It appears perverse that, while the law protects against the state causing citizens to commit illegal acts, it does not protect against private parties doing the same thing, where often the participation of the private entrapper goes beyond that which would be deemed appropriate by law enforcement officers. Many newspaper stings involve an expensive and targeted campaign on one individual based on limited or no intelligence, where the inducement is persistent and the primary incentive is to sell newspapers, not to prevent crime. David Slight, Kingsley Knapsley Solicitors, which also raises, again, the things that Leveson 2 was going to look at with a view to making recommendations to stop such things happening in a manner where things can be manipulated and fabricated, as we now know is what happened regularly with Mazher Mahmood. Mahmood's methods debase journalism. They often amount to entrapment and on occasion appear to involve the use of agents provocateurs. People have been encouraged to commit crimes they would not otherwise have conceived. As if that wasn't enough, the public interest justification advanced for such activities by the News of the World is almost always highly debatable. Speaks for itself. Panorama increases the strength of the case considerably for a new inquiry. There is a severe question mark over the tactics he, Mahmood, used. We are dealing with convictions which may not have been properly obtained. John Whittingdale, MP. There is a huge danger of accepting Mr. Mahmood's word in respect of any matter. Stephen Solly, QC. I am minded to refer the whole of this matter to the Attorney General to consider the temptations to which money being offered in return for stories, in particular about celebrities, gives rise to, and the way in which newspaper investigations may have a detrimental effect on the ultimate court proceedings. Judge Simon South. We've got Queen's Counsel, MPs, judges over the years questioning why was Mahmood allowed to use such techniques to manipulate people to do things they wouldn't normally have done. And the truth is, as we know from Steve Grayson, one of Mahmood's former work colleagues, they were the entire supply chain. They, as explained on Panorama with the Emma Morgan example, the person that she ultimately was manipulated into picking drugs up from was somebody that Mahmood had given the money to in advance to buy the drugs. In other words, Mahmood bought the drugs to make it happen. It's beyond belief. There must also be a review of Mazher Mahmood's previous work. There is a long rap sheet of complaints from Mahmood's previous targets. All those claims previously dismissed as special pleading up until now sound eerily similar to Kontostavlos. Reports, namely, that either Mahmood offered inducements to create the commission of a crime that would never otherwise have been anticipated. Mahmood manipulated or spliced audio recordings, thus providing police with inaccurate impressions about what was said or the context of it. Mahmood misled law enforcement. about the originator or instigator of a criminal enterprise, when in fact the origin was either Mahmood or someone in his pay. Alistair Parker of Brett Wilson Solicitors. All of that applies to me and the vast majority of Mahmood victims, as you can see at circusofthemind.net. How this went on for years, God knows. So what you're seeing there is a screenshot of Huffington Post from 2014. The key bit is there were no concluded cases where a defendant was still in custody. This is after the Talisa Kontos-Tavlos trial collapsed and the CPS said they were now investigating any active cases or past cases that involved Mahmood's testimony. And they were quoted as saying there were no concluded cases where a defendant was still in custody, but we identified 3 live cases. Each case was looked at individually and no evidence was offered as we concluded that there was no longer a realistic prospect of a conviction. In September, several trials at Southwark Crown Court in London were halted because they relied on evidence from the undercover reporter Mazher Mahmood. The CPS offered no evidence against Dr. Majid Ridda and pharmacist Murtaza Ghulam Hussain, who were accused of illegally supplying an abortion drug. And Fixer to the Stars Leon Storino Anderson and co-defendant Ashley Gordon, 21, had drugs charges dismissed after prosecutors said Mr. Mahmood was not a reliable witness. So the moment the Talisa Kontos-Tavlos trial had collapsed, any cases in the works were dropped. The CPS said they could now not proceed. Here is the thing. There is evidence to show that in 1994, that's many, many years prior to the Talisa case collapsing in 2014. Okay, so 1994, the police and the CPS both knew and communicated with each other, saying that Mahmood could not be considered a witness of truth, and also saying that they were considering interviewing him under caution about his activities. This was never disclosed to me or any other Mahmood victim. Why not? That case collapsed. There was a case collapsed in 1994, and there's other cases that collapsed since. Plus, they knew in 98, 99 time, as illustrated by the Panorama episode you can watch on circusofthemind.net, of Mahmood's links to Southern investigations, where again, he was marked as being someone who could not be trusted. Also around that time, but this is from January 2015, as you can see, the CPS prosecutors have dropped the case against 13 footballers investigated over alleged match fixing after considering the reliability of evidence from fake Sheikh Mazher Mahmood. Now, at this point, Mahmood has not been convicted of conspiracy to pervert the course of justice, but Talisa's trial has collapsed. And the Crown Prosecution Service said there was insufficient evidence to provide a realistic prospect of conviction in the case, given that they couldn't rely on Mahmood's testimony or evidence any further. Which means, had, for example, my case been in the works and live, or other Mahmood victims that you've seen on the Panorama documentary or heard about, had their cases waiting to go to court, that on the basis of what you've seen there, all active cases were dropped because they could no longer rely on Mahmood's testimony, which means ours would have been dropped as well. Which then further begs the question, why the sodding heck would we never disclose the information that they knew as far back as 1994 that Mahmood could not be relied upon as a witness of truth? There's communications between the police and CPS stating such as far back as 1994. Plus then in 98, 99, they knew about his links to Southern investigations whilst investigating the Daniel Morgan murder. And over the years, there's numerous cases that have collapsed, that have now come to light, that collapsed because of Mahmood's dishonesty or techniques being drawn attention to, manipulation of evidence, splicing of tapes, numerous reasons why things never got to court. All things that happened to me and to all the other people you see on the Panorama documentary and the vast majority of victims, as mentioned at circusofthemind.net. This is from, you can see down there, December 2014. But the CPS said that we're going to investigate 25 cases, because that's what they were aware of. Fake Sheikh cases to be re-examined in wake of judge's decision. Now, to quote from the article, the Crown Prosecution Service, CPS, is re-examining 25 cases in which people were convicted largely on evidence supplied by the Sun on Sundays reporter, Mazher Mahmood. It follows a judge's decision to halt the trial of Talisa Kontos-Stavros in July 2014 because he said there were strong grounds for believing Mr. Mahmood told me lies and had been manipulating the evidence. As we know since then, he did get charged and he did get convicted for conspiracy to pervert the course of justice. And in the years since, more and more evidence has come to light, including in the Mitville phone hacking High Court cases that show that Mahmood used unlawful information gathering, illegal private investigators, phone hacking, and also statements have come from people previously connected to Mahmood, such as Steve Grayson, who was on the Panorama documentary. You can see at circusofthemind.net, confirming that in the vast majority of cases, the News of the World as it was at the time, Mahmood's team, actually sourced and supplied the contraband, whether it was drugs, counterfeit money, whatever it was. They actually were the full supply chain from start to finish. The only criminals really were them. And as it says, and also that Steve Grayson pointed out that he witnessed Mahmood drugging somebody's drinks. So it's highly likely it did happen in the cases of all those people over the years who've made the claim that they believe their drinks were drugged or spiked, which did happen in the Talisa case as well. But it's happened with numerous people, as is illustrated again at circusofthemind.net. Now the CPS has announced it took steps after the collapse of that trial to identify current and past cases involving Mr. Mahmood as a prosecution witness. Its spokesman said, "We made it our immediate priority to carefully look into live prosecutions in accordance with the code for Crown prosecutors and any past cases which involved a defendant still in custody." It identified 3 live cases and concluded that there was no longer a realistic prospect of conviction, so the prosecutions were dropped. The next stage involved past cases that resulted in convictions based on evidence provided by Mr. Mahmood. Having identified 25 such cases, the CPS says it will be contacting representatives of the defendants or the defendants themselves in order to provide them with a disclosure pack. Okay, so this was the end of 2014 and it ran into early 2015 that the CPS were going to issue disclosure packs. This was their opportunity to let us Mazher Mahmood victims know of anything that could undermine our convictions. What we got was some information about the Talisa Kontos-Stavros trial. That is it. There was no mention of the fact in 98, 99 time Mahmood was implicated in the investigation with Southern Investigations and the Daniel Morgan murder and his dishonesty brought into question. There was no mention of cases collapsing over the years, which they did. There was no mention of the judges, the barristers, the solicitors, the MPs who questioned Mahmood's activities. There was no mention of the collapsed trials where there was evidence that, people went, well, this can't go on because evidence has been manipulated or there's lies taken place from Mahmood and his team. None of that, which they knew about, was ever disclosed to us, and not even in 2014 when they had this chance to do this. And they're making a big hoo-ha in the media saying they're trying to do things right, but they never disclosed any of this to us. But the CPS spokesperson said, when making a charging decision, each case and the evidence provided to us is assessed on its own merit and a decision is made in accordance with the code for Crown prosecutors. If, after the conclusion of proceedings, new material comes to light that may cast doubt upon the safety of a conviction, we have a duty to consider disclosure. By providing disclosure packs to the defence, consideration can be given as to whether or not this material might cast doubt upon the safety of any convictions. The CPS will provide information to defence representatives in order to allow them to consider whether there is a basis for their client's case to be referred to the Court of Appeal or to the Criminal Cases Review Commission. Well, as you know, mine is currently just gone into the Criminal Cases Review Commission after unfortunately not being granted permission to appeal out of time, as explained on circusofthemind.net. However, what that does bring to light, I'm just going to quote it again. If after the conclusion of proceedings, new material comes to light that may cast doubt upon the safety of a conviction, we have a duty to consider disclosure. Now, the chronology and timing is different for all Mahmood victims, depending on when they were stung and entrapped, depending on when the story appeared, depending on when they went to court. In my case, the article appeared in 1998, and I was convicted in early 1999. Okay. We now know that since early 1999, there were numerous cases that collapsed that never made it fully through court because, or where the person was found not guilty because Mahmood's dishonesty or arguably illegal techniques were illustrated and highlighted, and so they couldn't proceed or the cases collapsed. Manipulation of evidence and such like. None of this was ever disclosed at any point after. So, did they consider doing this as they go? Could they say that they have a duty to consider it? So, if they did consider it, why did they decide not to disclose it? Is it because of the implications of corruption that have come to light with the Daniel Morgan murder inquiry? Is it because Mahmood boasted of having bent police officers in his pocket? Is it that because of the things that Leveson Inquiry Part 2 was meant to be looking at that, fortunately, probably for all those involved, been swept under the carpet? According to the CPS spokesperson, though, the safety of convictions is of paramount importance to the CPS. Therefore, if defence representatives have not been contacted by the end of December, provided with a disclosure pack, then we would invite them to contact their local CPS office in order to provide their details and request a pack. Care should be taken when reporting matters relating to Mr. Mahmood. By early 2015, the disclosure pack was freely available to all and sundry. You could find it on the internet. And it contained very little anyway. All it had was a little bit about the Talisa trial and why it collapsed. There was nothing in there about all the other cases over the years that had collapsed because of Mahmood's dishonesty and messing with evidence and whatnot. Nothing in there about the 1994 collapse trial, of which documents of communication between the police and CPS do exist, as mentioned in my grounds of appeal at circusofthemind.net. So, as John Whittingdale said, Panorama increases the strength of the case considerably for a new inquiry. There is a severe question mark over the tactics Mahmood used. We're dealing with convictions which may not have been properly obtained. It's likely that pretty much there's probably hardly any Mahmood conviction properly obtained. He was responding for a call for an investigation into Mahmood's string of stories by lawyer Siobhan Egan, who represented one of the men charged with the kidnapping of Victoria Beckham in 2003. That Victoria Beckham kidnapping story has now been totally exposed as nonsense that was fabricated and manipulated and made to happen by Mahmood and his team. And on the 2nd of November, I say the 2nd of November, it's not the 2nd. I'm going to give you the correct date. It's the 3rd of November, 2022 will be exactly 20 years since the Beckham kidnap story that was fabricated and manipulated by Mahmood and his team appeared. It's just, they knew then. And when that happened and they knew about all that, did they contact us Mahmood victims and go, we should tell you about this Beckham kidnap case and the dishonesty and manipulation and all that that's gone on with Mahmood and his team, because similar might apply to you, which it did to all of us. No, they didn't. Massive non-disclosure failures. So regarding Leveson Part 2, which sadly got swept under the carpet, there's lots of myths about it. It did get swept under the carpet, but the point is, Part 2 would have looked at how major newspaper corporations developed and maintained a culture of criminality over many years, damaging the lives of numerous victims. It would have looked at the police and the CPS's involvement and some would allege dishonesty and corruption. You've only got to look at the Daniel Morgan murder inquiry, which is mentioned at the bottom here. The same applies to the family of Daniel Morgan murder. Now, also, as you can see here, Mazher Mahmood, the fake sheikh, was convicted only relatively recently when this article was published. There has been no investigation into his illegal activities over many years and his relationship with police and prosecutors. But as you saw before, judges, MPs, former attorney generals, people in high powers have all said there should have been a proper investigation. And the CPS implied they were going to do, but it's never happened. What's being hidden? Saying that 11th Part 2 is not supported by the public, well, you can see a list of people there that most definitely do support it, want it to take place. But it's been swept under the carpet. The Conservative government, no doubt, as some have pointed out, perhaps as a thank you or a bribe to the media, have shelved Part 2 of the Leveson inquiry. So if you go to circusofthemind.net, on there, you'll see a bit that says the Daniel Morgan murder inquiry. Go there, you'll see how Mahmood was mentioned in that, and the bigger picture of police, corruption, Crown Prosecution Service arguably covering things up or not disclosing them as well. You'll also on there be able to download my perfected grounds of appeal, within which you'll see the following things. There was a significant failure by the Crown Prosecution Service to comply with their duty of disclosure in that material in the possession of the prosecution at the time of the applicant's case, that's me, my case back in 98/99, which seriously undermined Mahmood's credibility, was not disclosed to defence. It wasn't. Nothing was given to me, despite the fact we now have knowledge that in 1994 the police and CPS communicated with each other saying Mahmood should not be trusted and that perhaps they should consider interviewing him under caution about his activities and dishonesty. This has only come to the attention of the applicant very recently, me, as a result of witnesses that have come forward and information that has been supplied to the applicant relating to the News Group Newspapers Limited phone hacking litigation. Lawyers acting for one of the claimants, John Shannon, aka John Alford, have recently contacted the applicant, me, Jonathan Royal, Alex Smith by birth. This is dealt with in my second witness statement. In summary, News Group newspapers have disclosed material, generic disclosure provided from News Group newspapers archive in December 2020 to Mr. Shannon in the phone hacking litigation, which demonstrates the Metropolitan Police knew that Mahmood was an untruthful witness back in 1994/5, i.e. way before my case. News Group newspapers was in possession of police and prosecution documents identifying Mahmood as having given false evidence in a 1994 court case, showing the police to be reluctant to prosecute further cases based on Mahmood's activities and suggesting the police would need to interview Mahmood under caution in relation to a subsequent article. Whilst the existence of this material has been drawn to the applicant's attention, that's me, the applicant is not able to adduce it at present owing to legal restrictions on the use to which it may be put. The applicant may seek an order from the Court of Appeal Criminal Division to facilitate its use, or ideally the Criminal Cases Review Commission will hopefully exercise their powers to obtain these documents from the Mittville phone hacking court records, which show without a doubt that the Crown Prosecution Service and the police knew back in 94 and 95, predating my case, and yet they never disclosed prior to my case or any time since, and they've had multiple opportunities, any of that. Severe disclosure issues. They'd been known about, the case would never have got to court, my case, I believe. At the time of my case, the CPS were aware that at least one other case that depended on evidence from Mahmood had collapsed, and yet this was not disclosed to me at the time. In R versus Shepherd and Norman, in 1994, a decision to offer no evidence was taken by the CPS based on the fact that Mahmood, one of the main witnesses for the prosecution, had given misleading evidence, which in turn led the prosecution to mislead the accused and his defence representatives. Incidentally, this is redolent of the occurrence 20 years later in 2014 when the Talisa Kontostavlos trial collapsed at Southwark Crown Court due to Mahmood again giving false evidence. I'd say further, it's consistent with what I've heard from other Mahmood victims and what I experienced myself over the course of time of decades. Also mentioned in my grounds of appeal is the fact that a number of other victims of Mahmood have complained of drink spiking, which demonstrates a modus operandi to Mahmood's unlawful entrapment. And we have a statement from Steve Grayson saying he witnessed such, which is part of my appeal bundle. And the fact that the CPS were aware at the time of the applicant's case that Mahmood was an unreliable witness, and yet they failed to disclose this fact to me, despite at least one other Mahmood case collapsing over concerns about Mahmood's credibility prior to my trial in 1999. But since 1999, numerous cases collapsed over Mahmood's lack of credibility, lack of truth, messing with evidence and various other things, and none of them have ever been disclosed to us, even when they were given the chance in 2014 when they sent us the Talisa disclosure pack. These are things that, had we known about them at the time, would have enabled us to get a stay in proceedings, or maybe even to stop things ever going to court in the first place. They most certainly illustrate the conviction that unsafe. The police and CPS were aware of Mahmood's suspected dishonesty before the time that the applicant was charged and prosecuted for these offences, but that was not disclosed to me in advance of trial. Had the applicant been aware of Mahmood's suspected dishonesty, i.e. through disclosure, such information may have given rise to an abuse of process argument and or led to the applicant maintaining his not guilty plea, because I pleaded not guilty right up until the first day of trial, where I was given what I now know to be misleading or incorrect, unwise advice that my continuing to plead not guilty and challenging Mahmood's credibility apparently at the time wouldn't have worked, I was told. Well, if I'd have been given the disclosure I should have done, and then I could have challenged the credibility of Mahmood's evidence, and I feel confident that I would have been found not guilty in those circumstances. Although more so, I'm advised and believe that it just would never have got to court, or it would have got a stay in proceedings and thrown out of court at that point. So, also, since lodging the initial version of my settled grounds in February 2021, it's been drawn to my attention that there is evidence that Mahmood used unlawful investigative techniques in his investigations, including phone hacking of me, which you can see in a statement I've got from Glenn Mulcair. And there is a clear evidential basis to assert that Mahmood used private investigators who employed unlawful techniques, including phone hacking, in his entrapment of me, and that Mahmood subsequently lied about this to the Leveson inquiry. Had this been known about at the time of my guilty plea being made on the first day of trial, where I changed it, as I previously mentioned, it would clearly have given rise to an abuse of process submission. This is all detailed and mentioned in much greater depth on circusofthemind.net, but as you can see in 2018, here from The Guardian, CPS and police routinely failing to disclose evidence. From 2020, CPS struggling to cope in disclosing evidence to defendants. 30th of June 2021, 1,648 cases collapsed over disclosure failures. 1st of November 2021, twice as many cases collapsed last year over disclosure failings when compared to 5 years ago when crisis identified. When you look at circusofthemind.net and look at the Daniel Morgan murder inquiry findings of corruption and cover-ups, incompetency, it also illustrates that this has been going on for decades, and it's no wonder that it wasn't disclosed to me or the other Mahmood victims that they knew back in 1994. Was that corruption? Was it cover-up? Or was it just plain incompetence? It could be one, all of them, or a combination. Who knows? But the truth, hopefully, will in time, now that things are in at the Criminal Cases Review Commission, actually come out. And finally, please reinstate Leveson Inquiry Part 2. It really is required to uncover the full depth of all of what's really... Well, there you have it. And my grounds of appeal, together with various other documents that illustrate stuff that I've spoken about, and the panorama video and other videos that prove stuff, are at circusofthemind.net. So, please circulate this, make people aware. Lobby your MP even to reinstate Leveson Inquiry Part 2 and to actually have a proper investigation into Mazher Mahmood's illegal and dishonest techniques.